My first job out of law school was researching decisions for the Washington Court of Appeals. So I have a pretty good understanding of how courts go about reviewing a legal memorandum like Amber Heard's post-trial motions, how they evaluate it, and how they make their decision about whether she is entitled to any of the relief that she's asking for. I'm going to go ahead and give that treatment to her post-trial motions. This is an extensive filing that asks Judge Azcarate to do several things: to set aside the verdicts in Johnny's favor, to dismiss his complaint, and then to investigate allegedly somehow improper service by juror number 15. We're going to work through these arguments pretty systematically. She provides a good outline of where she is going in her table of contents, and then she gives a summary of her argument that essentially tries to capture the points that she's making for each of her various headings that she addresses in her argument. From a legal standpoint, the meat of her argument is in the argument. That's where she's got her legal citations. That's where she's got the facts that she argues supports the interpretation of the law that she's offering. And so that's where we're going to focus our attention. So the first thing she's arguing is that the damage award is unsupported. Virginia has a legal process called remittitur that allows a trial judge to reduce a jury verdict if they find that verdict has been influenced by passion or prejudice or rests upon a misunderstanding of the facts or law of the case. They can also reduce the verdict if it is so clearly out of alignment with the evidence of damages that was presented at trial that it suggests the jury was not basing its decision on the proper considerations. Elaine cites a number of cases that she's arguing supports her claim for remittitur. She starts with Polson versus Rock. As a bellwether of her claim, this one is not a positive one. Polson versus Rock is a case where the trial court granted a remittitur on a defamation per se verdict, and that decision was then reversed by the Court of Appeals. Normally, if you have good cases and bad cases available on your claim, you choose to lead with the one that is the strongest so that the court's first impression of your claim is that it is well grounded in the law. So the fact that Elaine is opening with a case that results in the opposite outcome that she's looking for doesn't really bode well for her request. Now, in Polson versus Rock, what happened is the trial court looked at the evidence in the case and concluded, hey, this person didn't suffer severe reputational harm, their friends didn't even believe the accusations, their job didn't believe the accusations, they had no professional consequences, lost no income, and didn't apparently have any type of, medical or emotional distress that would require therapy or those types of costs at all. So really the only thing that the jury verdict was compensating the plaintiff for was just the embarrassment and kind of inherent damage that a person suffers by being falsely accused of something terrible. And so the Court of Appeals concluded that there was no basis to determine that the jury's verdict under these circumstances was excessive. There's no obligation for a defamation per se plaintiff to prove actual financial damages. The jury can presume the harm that flows from the accusation. And so by focusing unduly on the lack of evidence that it perceived, the trial court misapplied the standard for defamation per se and made a decision to reduce the judgment amount that the Court of Appeals concluded was an abuse of discretion. If that sounds to you like it doesn't particularly benefit Elaine's position, that's correct. And much of her other case law doesn't as well. She cites Gazette Inc. versus Harris. This was a defamation case where the court upheld a compensatory damage award, even though, again, there was no proof of monetary damage, and the only real injury that the award was based on was the type of embarrassment, suffering, injury that a person would ordinarily encounter. And the only other binding authority that she cites, or at least precedential authority, is Richmond Newspapers versus Lipscomb, which is a case where there was a remittitur and the Court of Appeals approved it, but there was absolutely no discussion in the opinion of what the remittitur was based on, why it was granted, why the damages were excessive. So there's very little to draw from as an analog to Johnny's case in order to understand why the court reached that outcome. All we really know is that it did reach the outcome, which isn't particularly helpful. The other cases that Elaine cites are not precedential. They are decisions from other circuit courts in Virginia, meaning they're at the same level as Judge Azcarate. They are trial judges looking at different factual scenarios and making different decisions. And so those two cases not only are not binding on Judge Azcarate, but they aren't particularly factually similar either. The first one, Thomas versus Simus, I don't even know how to say that, but whatever, was a case where a city auditor got criticized by a city council member in some broadcast interview and subsequently lost his job, sued and claimed, a variety of distress and damages and stuff, and ended up getting a $350,000 verdict. And in that case, the court said, well, there was really no evidence that he suffered any loss that was particularly attributable to this broadcast. He couldn't even identify somebody who had seen it. And he also couldn't distinguish how he was harmed from this broadcast interview versus the harm that he incurred just a short time later after he lost his job. So under these circumstances, that particular court concluded, yes, $350,000 is excessive. We are going to bring that down to $100,000. The second case is Sheckler versus Virginia Broadcasting Corporation. And that was a situation where there appeared to be pretty good evidence of inflammatory argument by the plaintiff's attorney. It involved false reporting, essentially, and the attorney was kind of hammering on stories that were in the press at the time about this reporter, Jason Blair from the New York Times, who had been discovered to have basically falsified a whole bunch of stories and was ultimately, I believe, fired for that. So again, pretty different factual situation. In that one, there had been a compensatory damage award of $10 million. The court concluded that isn't justified by the evidence of the case. We're going to reduce it down to $1 million. So all in all, these cases don't necessarily make a strong showing that somebody in Johnny Depp's unique situation, a guy who is famous around the world, makes hundreds of millions of dollars as an entertainer, and is accused publicly of these horrendous types of accusations. There really is nothing like that as a matter of precedent in Virginia. Johnny Depp is always going to be a pretty unique plaintiff in these situations. So how Elaine approaches this argument, it's really annoying. It's honestly one of my pet peeves. The no evidence argument. She just baldly says, there's no evidence to support this claim. And then she goes through the brief and just talks about all of her own evidence as though that was the only thing that was presented at trial that the jury would need to hear. The thing with this type of legal argument is that the court is very cautious not to step on the toes of the jury. It's the jury's job to resolve questions of credibility, who do we believe, to reconcile conflicting facts. If there are competing versions of events, for example, the staircase incident, they heard multiple different versions. It's the jury's job to reconcile that into what they think took place. And so the Court of Appeals is not going to step in and redo those types of decisions that the jury made. Instead, what they're simply doing is making sure that there was something that the jury could rely on in order to reach that decision. So for practical purposes, what that means is they are looking at all of the evidence in the case. They are looking at all of it in the light that is most favorable to Johnny. So assuming the jury believed all of his evidence, found all of his witnesses credible, drew all of the inferences from the case in his favor, then under those circumstances, because the jury is entitled to do all of those things, under those circumstances, would there be sufficient evidence to support, in this case, the verdict? So Elaine focusing on her own evidence here is a big miss and just a big tell. It's really obvious she can't frame her argument the way she should in terms of showing the insufficiency of Johnny's evidence of his damages, because he in fact has quite a lot of evidence of his damages. He had testimony from Christian Carino that he lost Pirates 6 because of Amber's accusations. He had testimony from Richard Marks that before the accusations, Johnny was one of the most successful actors in Hollywood, that after the accusations, he ran into this cancel culture type of mentality. And then after Amber published the op-ed, that just went to a whole new level because of the allegations of sexual violence and domestic violence. And he became radioactive and suffered tremendous career damage. He had Doug Bania, the social media analyst, who testified that Johnny's perception first took a hit in 2016, but then after the op-ed was published, it was even worse. He had testimony from Michael Spendler, his forensic accountant, that Johnny lost out on approximately $40 million in income in the year after Amber Heard published the op-ed. And he had testimony from Jack Wiggum, his agent, that he had in fact closed the deal to do Pirates 6 with Disney for $22.5 million, that the deal just needed to be written up by the lawyers, but then Amber Heard published the op-ed, and Disney suddenly decided they were going to go in a different direction, and Johnny ended up not getting a studio film for nearly 2 years after that. All of these things are evidence. All of these things the jury is entitled to believe and to treat as supporting Johnny's claim, not Amber's. So the no evidence is just a terrible, groundless approach to this type of argument, and it's really going to cost her credibility. Anytime you see this no evidence in a brief as a law clerk, I mean, that's just a red flag. It's just a flashing light that tells you, proceed with caution, verify what this person has to say, because chances are there probably was some evidence. They're just choosing not to tell you about it. Elaine makes this rather bizarre argument about Camille's opening and closing statements. She argues that because Camille talked about Amber Heard first lying about Johnny Depp in May 2016, that somehow that then communicated a request for damages from 2016. Her point is that he had a limited time range in which his damages could be calculated. But there's several problems with this argument. On the face, she hasn't quoted Camille saying, give Johnny Depp damages beginning in May of 2016. She's just drawing this inference from a kind of unrelated claim that Camille is making about how this whole situation unfolded. What is the context for the jury to read and understand the op-ed, to make sense of the 2 years ago I became a public figure, etc., etc. So there's no way to tell this story without talking about May 2016. That does not in any way mean that it follows that Camille was somehow asking for damages from 2016. So just on its face, very bad interpretation of Camille's argument. Problem number 2, Elaine didn't object to Camille's argument when she was making it. It's pretty much a basic rule that if you think the other side is doing something wrong in a trial, your job is to object. And if you don't object, you waive that complaint. And the reason why is because you need to give the court and the other side an opportunity to fix the problem. You don't get to just sit back, play victim, and then argue that you were injured by this line of reasoning that you never interrupted, never took the opportunity available to you to say, hey, this is improper and it needs to be changed. No objection pretty much waives any objection to Camille's argument. Problem number 3 with Elaine's argument here is that the jury was already correctly instructed on the limitation period for the damages, as well as the fact that the damages needed to be caused by the op-ed. Elaine makes this long argument that, oh, there were all these alternative causalities, basically meaning other things were going on that could have damaged Johnny's reputation, and the jury's not allowed to take those into account. Yes, Elaine, we know that. That's why we instructed the jury not to take those things into account. There's no showing of error here. There's a general presumption that the jury follows the instructions that it's given. So if she's not able to point to a misunderstanding of the law, the fact that they disagreed with her on the evidence is not going to be a justification to reduce the verdict. So bottom line, this argument to reduce the damages, it's really some trash. It ignores Johnny's evidence. It ignores the jury instructions. It twists the argument that Amber started accusing Johnny Depp of abuse in 2016 and then referenced that in her op-ed in 2018 when she talked about 2 years ago, and somehow distorts that as a type of claim for damages that she didn't object to at the time. So this is not a strong showing for relief. She did not present good case law to support her request. My prediction, damages award is not going to get reduced. Second argument she makes, the verdicts on the complaint and the counterclaim are inconsistent. It's basically cherry-picked selection of descriptions of the case, generalizations about the case from letter rulings the court had issued and statements that were made in various arguments, because from the 10,000-foot view, the case is indeed about who is telling the truth. Did Johnny abuse Amber, or did Amber abuse Johnny? The problem is that there is no particular inconsistency with the verdicts. They are very easily reconciled. The jury specifically did not find that calling Amber Heard's accusations an abuse hoax was defamatory. That was two of the three claims that she had made that the jury rejected. It was only the second counterclaim, which spelled out Adam Waldman's account of how the hoax was carried out, was the one that the jury presumably found was untrue and therefore imposed liability based on that. So those aren't inconsistent positions. It doesn't mean that she didn't actually perpetrate an abuse hoax. It just means that in the jury's mind, the way that Adam described it is not the way it happened, and as a result, that was defamatory. I don't think this argument is going to go anywhere. The third argument she makes on the First Amendment, goodness, Elaine has actually identified an interesting legal argument. This argument has gotten a fair amount of attention because she has found some case law that she cites that does support this position that she's arguing, that essentially because the First Amendment gives the most protection to speech involving public officials, public figures, and matters of public concern, that they are limited then to recovering only for statements that are false. And so the problem with defamation by implication is that it can be applied when the statements at issue are technically true, but nevertheless carry a defamatory meaning. So these cases essentially conclude that because a statement must be false to meet the actual malice standard for public figure defamation, that would preclude then a defamation by implication claim from going forward where the statement is in fact actually true. So this is a pretty interesting legal argument. It stems from a couple different lines of authority that I followed through. One of them comes out of the state of Louisiana having its criminal libel statute found unconstitutional by the U.S. Supreme Court in a case called Garrison versus Louisiana. Louisiana then took that decision a little bit further than the Supreme Court ever did to reach this conclusion that defamation by implication would be precluded for a public figure. But the U.S. Supreme Court themselves have never announced that position. There's a second line of cases that come out of some federal case law that arose out of the Leonard Peltier's arrest and incarceration for the shootout at Wounded Knee, if that's a cultural reference that you're familiar with, just kind of a point of interest. People had written books about that incident, and so one of the FBI officers who was present during the shooting sued the publisher, basically claiming that it was defamatory. And so in this line of cases, the Eighth Circuit Court of Appeals looked at the question through the lens of, is this a statement of fact or is this a statement of opinion? It's one of the kind of ground rules of defamation litigation that opinions are protected. Everybody has them, everybody is entitled to them. It's only false statements of fact that tend to damage a person's reputation that you can recover for in a lawsuit. So these cases look at this 4-factor test for determining whether a statement is a statement of fact or a statement of opinion. It looks at the specificity of the statement, whether it's the type of thing that is verifiable. What is the literary context? Is this a hard news item or is this TMZ? And then they look at the public context. What was the overall conversation at the time, the context in which people would have understood these statements. So in those type of contexts, these decisions reached the conclusion that the types of defamatory implications that were being urged here were simply matters of opinion. They dealt with conclusions that, for example, police officers were not doing a good job. People were committing misconduct, politicians were corrupt, things along those lines that can sound a lot like solid assertions of facts, but can also just represent a person's opinion, their reasoned conclusion from having looked at a story in detail. So on first glance, this also looks like, wow, that's potentially a good argument for Elaine. There's all this case law that supports it. But as usual, there are a number of things that cut against it. So first off is that the Virginia Supreme Court itself has not accepted this distinction. So these other circuit courts base their decisions on the fairly common sense, realist, pragmatic notion that communication operates through signaling, through innuendo, through implication, that there's a lot of things that we say without saying. And so to fail to recognize that reality would really not be recognizing just the truth of how communication works, and it would be opening the door to essentially allow whoever is crafty with their language to get away with casting atrocious aspersions on people without any consequence, just because they don't literally and explicitly say what they are actually communicating. So this is an interesting legal argument, if not exactly the strongest one for Elaine. But once again, there's a flaw in it that, in my opinion, is probably fatal before the court ever even goes down this road of analyzing all of these legal cases and the lines of authority and the circuit splits and so forth. And that's, once again, in the jury instructions. The verdict form that the jury was specifically asked to rule on has them answering two really critically important questions here. The first one, Chapin says, the rule from this circuit is simply that a public figure plaintiff has a heightened burden to show a defamatory implication. They must show that that defamatory implication was intended. So what did the jury find? Did Amber Heard intend and design the defamatory implication? Yes, she did. The Chapin standard is satisfied. There is no First Amendment problem. But even beyond that, what did the jury find here in the verdict form? The statement is false. They found the statements false. Now remember, this whole line of reasoning comes from the idea that you can't have a statement be facially true and defamatory by implication in order to find actual malice against a public figure plaintiff. That's not our situation. The jury found the statements false. They found, Amber Heard, you did not become a public figure representing domestic violence. You did not feel the full force of the culture's wrath for speaking out. You just lied about Johnny Depp being an abuser, and you tried to capitalize on that for your own benefit. What's interesting here is that this finding only exists because Amber's team required the verdict forms to read this way. Back in the instructions conference, Johnny Depp had been asking for the jury to only have to find that the defamatory implication was false. They made this specific argument that there is authority, that a statement can be facially true and yet nevertheless carry a defamatory implication. That's how they wanted the instructions to read. But that's not the instructions Judge Azcarate gave. She gave the ones Amber's team requested. They thought that it was going to give them this opening to convince the jury it's technically true. Go ahead and let her off on a technicality, because newspapers did write about her in domestic violence. Therefore, it's not a false statement. The jury didn't buy that argument. They were given the law. They were asked to decide. They decided it was false. This argument fails, and the First Amendment issue is not even going to get off the ground in light of that finding. The next argument Elaine makes is essentially just a repeat of the argument that they made on their motion to strike when Johnny rested his case. And that argument was that the tweet, Amber Heard's tweet of the op-ed with the sexual violence title, was insufficient to constitute a republication. So she starts by, again, no proof, no evidence, because Amber said. She puts out her own case as though it's the only version that the jury heard and the only thing that they had to consider, and argues, well, Amber said she didn't even see the headline when she made that tweet. The jury gets to decide credibility. They are under no obligation to accept anything as true simply because Amber Heard said it. They are entitled, in fact, to assume that if she said it, probably something close to the opposite is closer to reality. So that telling is not binding on the jury. They were entitled to take account of the whole circumstances that they heard with the ACLU witness about the drafting of the op-ed, its submission for publication, and so forth. But once again, Elaine then relies on this law that just doesn't support her position. Her bottom line here is that just republishing a hyperlink is not sufficient to constitute a republication. And that is correct. But Amber Heard didn't just republish a link to the op-ed. She added commentary to it. She created a short tweet thread about it that the jury saw. She undermines her own argument in this kind of amusing way, in my opinion, where she argues that, well, Amber didn't even have control over whether the headline appeared in the digital version of the article that she was tweeting. Because that just emphasizes that she had control over whether to retweet it, and she had control over what she chose to say about it when she did. She chose to validate, ratify, and not explain or in any way suggest that the sexual violence headline was misleading or was about something else. She let it go forward. So again, this just became an issue for the jury to decide. They were properly instructed on this requirement. They had the evidence. They were entitled to decide it, and they did. She's not going to win on this issue. The last two trial issues, the insufficient evidence. Again, this is just the same thing we've already talked about. Elaine just goes, no evidence, no evidence, no evidence, and she doesn't look at Johnny's evidence. She doesn't look at what the potential inferences from the evidence are. So when she argues no evidence of actual malice, her position is that, well, Amber Heard had to have entertained actual doubts, and since she's insistent that it actually happened, therefore you can't show that she actually didn't believe it. The jury is not obligated to accept that explanation. The jury is perfectly entitled to look at the case as a whole and decide Amber Heard abused Johnny Depp, lied about it, accused him of abusing her, and then created a bunch of false evidence to substantiate her version of events. I think from that I can infer that she knew she was lying. You generally don't have to perpetrate a hoax for something that you have a sincere belief is true. This one is not going to go anywhere. There is abundant evidence of actual malice. And then the insufficient evidence of defamation by innuendo. This is just going back to the losing argument she gave the jury that it wasn't about Johnny, and especially the headline. Nobody would have understood the headline to be about Johnny because she had never accused him of sexual violence before. But of course, the problem is that all of the statements have to be read in the context of the article as a whole, and the article was signposting that 2 years ago, when she became a public figure representing domestic violence. So that is the context available to an average reader to understand what it is she's talking about. It is reasonable and foreseeable that people would understand that to be about Johnny Depp. There was substantial evidence from including Jack Wiggum and Richard Marks that those allegations of sexual violence were actually understood to be referring to Johnny in Hollywood. And so, therefore, that is going to be enough. The last sort of interesting technical argument Elaine makes here is a claim that if this is all arising from the original accusations Amber made in the domestic violence TRO, that those are judicially privileged statements. They took place in a court proceeding, therefore she can't be sued for them, and therefore republishing them cannot be actionable as well. But the problem with that is that it ignores the many things that Amber Heard did to try to craft and influence this perception of Johnny Depp as an abuser, besides the allegations that she made in the temporary restraining order. For example, the leaking of the kitchen cabinet video to TMZ. These are circumstances outside of the courtroom that added to that context that would not be privileged and that the jury could rely on as providing the basis for what the reader would have understood in 2018 about the context of 2 years ago. So now this last issue here, this bizarre request dealing with juror number 15. This is just strange. I have my own theories about what is potentially happening here. I do wonder if this is going to be the straw that breaks the camel's back when it comes to Judge Azcarati's will to sanction for inappropriate behavior. I guess we'll have to wait and see. The bottom line here is that there's apparently some discrepancy in the birth date. The list said 1945. Elaine has researched it and said it's probably more like 1970. It's clearly not correct. Therefore, the clerk's office didn't properly verify the juror under the statutory requirements. And she's cast this as some type of improper jury service issue. Now, by her own acknowledgement, this statute does not give rise to any argument on appeal. It specifically says that. So it's not an error that she can point to as justifying any kind of relief. And indeed, she's really not even asking for any kind of relief. She's asking for an investigation into the circumstances. But there are several problems with this. Obviously, Elaine had the jury list going into voir dire. She could have identified the discrepancy. She could have questioned the juror about it. She could have otherwise ascertained if there was any type of problem with his service. She clearly accepted him as a juror and found nothing objectionable about him. So once again, this is likely to waive any issue that you have with this juror, short of some type of misconduct. And you saw, for example, in the Ghislaine Maxwell trial that there was an argument the juror had failed to disclose information about a prior sexual assault that should have been brought out, admitted during the jury selection process. And she argued that was the type of misconduct that essentially renders the jury selection unfair. It didn't succeed in that case. Elaine is not overtly coming out here and making this implication. But what she is doing is she is saying, well, this problem might implicate due process. And due process it's a constitutional issue. It's dealing with the fundamental fairness of the trial process. And so there are certain types of errors that are so fundamental, so structural, that if they occur, they just render the trial a sham. It has no integrity as an objective fact-finding process. And so these are usually things like bias, corruption, misconduct. I have to wonder, before Elaine starts waving it out there that maybe juror number 15 engaged in misconduct and the court should investigate that, did she do any investigation of her own? Did she ask the clerk's office, hey, what's the deal with this jury list? Did she contact juror number 15 and ask him, hey, what's this deal with the 1945 versus the 1970? Does she have any basis whatsoever to be wafting these hints of some impropriety on his part into the ether? I do have to wonder that. And part of the reason why I think this could potentially be the straw that breaks Judge Azcarati's back and finally gets Elaine sanctioned for making baseless and frivolous claims to the court is the fact that judges tend to be very protective of their jurors. They understand and appreciate that service is a hardship for most people. It's something they do because they have a sense of civic responsibility and recognize the importance. And so they are not going to take kindly to somebody casting aspersions on one of these jurors who responsibly served. Making this type of accusation, implied as it is, of impropriety is the kind of thing that you would probably expect somebody to have a good faith basis in facts, in evidence, to be able to levy that accusation. So if Elaine doesn't have that, wouldn't surprise me if Judge Azcarati is not particularly happy about that. And indeed, the very unlikelihood of any type of real benefit to Amber from raising this issue in the first place really just makes me wonder if this is just kind of a final game of chicken, a last little dare, a last little bit of impunity Elaine is going to put out there and dare the judge to keep her in line. Gotta tell you, if Judge Azcarati read it that way and responded appropriately, that wouldn't upset me at all. So that is Amber Heard's post-trial motions. The bottom line, I don't think any of these are going anywhere. I don't think it's going to be especially difficult to reject them. I don't think any of them set up particularly good arguments for appeal. This is just one more example of the ranting type of advocacy that we have come to know from Elaine, with the bald assertions and the ignoring inconvenient facts and law, and the effort to spin both of those in a way that benefits her, but ultimately her opportunity to sell that spin was to the jury. Having failed to do so, I don't think Judge Azcarati is going to change anything now. Thanks so much for joining me. I hope you've appreciated this breakdown, and I will see you next time.